Hello everyone, and welcome to another Vanguard Employer Educational event. Today is November 18th, Wednesday the 18th, and I welcome everybody to our webinar today. Today we have a great topic. We'll dive into employer contributions, all you need to know. If you have any questions along the way, please feel free to type them in the chat. We'll make sure that we get answers to all your questions after the fact. And of course, we always send out the slide presentation and a recording to this video presentation after the fact. One thing I do want to just comment on before we dive into the content, one of the questions we get quite often this time of year is from sole proprietors or sole practitioners of businesses and corporations. The Affordable Care Act has changed the definition of what a small business is, and insurance companies have followed suit now by incorporating that definition into their underwriting requirements. So always this time of year, we get a lot of questions from business owners and sole proprietors that even if they have employees, if there's employees that are not covered under the plan and the owner is the only person that wants to be covered under the group plan, it has now become a very challenging task. And so something that owners should be aware of, the definition has changed, and just to do a broad scope of it, is that if you are a business owner and you do not have a partner in your business, you do have 2 or 3 employees and you are the only person, or a family member, meaning a spouse, are the only people that are taking coverage, insurance companies now define that as a sole proprietorship. So that is now leaving the exchanges and individual market, which are a lot less robust than plan choices, as alternatives for business owners. So it's something that business owners have to be aware of this time of year as we're in the open enrollment season for the exchanges. You should be prepared ahead of the renewal of your group plans or your anniversary of your plans, and be aware that there may be audit requirements coming from, depending on what carrier you're with, to determine if your business is a sole proprietorship and not an employee. And I think there's some misinformation, or I should say misunderstanding, of that regulation, because an employer who has employees, you would think that that would be enough and a proper definition of a small group, but in fact it is not the case. And you should be aware of it for audit purposes and for plan choices. We're finding that a lot of employers are contacting us and being left that they have no choice but to go to the individual market and the exchange. One other way to get around that is if you do have a partner of a business and your partner is waiving coverage and you do not have any other employees enrolling on the plan, that will actually be allowable by insurance carriers. So if you have any questions on that during this time of year, give us a call. We're happy to help. With that, I want to dive right into the content of today's webinar. Today, we're going to be talking about employer contributions, all you need to know. And this is one of the most common things we advise our clients on, is how to design an employer contribution that not only is compliant, is attractive to employees from a recruiting and retention standpoint, but also fixed so that it stays within an employer's budget. Those are 3 areas that really are concerning to an employer when they're designing it. And we'll dive into some different strategies that might be attractive. We'll also dive into some compliance aspects of designing an employer contribution, because now that over the years, as plans have increased cost, employers are looking more and more at plans that have increased costs, higher deductibles, and they're looking more and more at how they can design an attractive package to their employees without having to pay for the entire amount, and how to pass cost share on to employees that's attractive to them. So we'll talk a little bit about that. And it is one of the things that we advise our clients most on. So we have a unique perspective, and I'll try to give some examples, some real life examples as we go away. So employers are designing a health and welfare benefit plan. They often wonder, what are the rules? what do I have to comply by, and how can I go about doing this? So some employers will go about providing benefits using a flat amount. So a flat amount is one common way to go about providing a contribution to your employees. So you can go about making a fixed dollar amount, which has become more and more common over the years as increases in health insurance costs have materialized. So you can go with a flat dollar amount, and that is becoming more and more common, where you pay a fixed contribution dollar amount for each tier. Now, some employers will pay for single only, meaning that they'll pay a flat dollar amount of, let's call it $500 a month. And that flat dollar amount, the employee can use that to buy coverage for themselves or coverage for their dependents. However, it will be the employer's contribution will be fixed at that amount, which is very important from a budgeting standpoint. So in those type of plans, employee onlys have very high incentives and usually are more incentivized to take the plan, whereas families and other dependents there's higher contributions that would go towards that. The other thing employers can do is charge a percentage amount, and that percentage amount can be varying from a perspective of the tier. So you can say we're going to contribute 80% to single employee coverage, and we're going to contribute 50 for all dependent tiers. That is compliant. The one rule of thumb that you want to, and this is just very general in a basic way, is you want to make sure that when you're designing an employee contribution, you're consistent in your approach to providing benefits, meaning that you're not doing for one class of employees. If you're staying within one class of employees, you should be consistent with all the employees that are in that class. We'll get into some things that you can do where you can change contributions based on the class of the employee. However, if you're in one particular class, if you have salespeople and salespeople are charged 80% or contributed 80%, I should say, and they pay 20, every person in that class should get the same percentage. So charging a percentage is definitely one of the more popular ways employers design their contribution strategies. However, that is diminishing more and more, because when you are an employer and you're giving a percentage of a premium, as those premiums increase, so does the employer contribution. So there are many times where we advise on flat dollar strategies, because now if you have a flat dollar strategy and you offer a multitude of options to your plans, employees start picking plans that work best for them, not just because they get the highest percentage to that plan, and therefore they'll wind up picking more prudent plans for their needs, which drives down costs for them and for the employer. And then you can also, we talked about using a set dollar amount that they can offset whatever plan and whatever tier they choose, but also sometimes employers will give them a flat dollar amount, and then if they pick a plan that falls below that flat dollar amount, then they can use that for other coverages like dental and vision. We're working on one right now where the employer pays just about $8,000 a year towards employee coverage, and they offer several voluntary type of benefits. They offer dental and vision and life and disability, and they've given the employees the flexibility that if they want to choose a plan that falls below their contribution, they can take those dollars and use that towards other ancillary coverages like those dental and vision plans that we're talking about. So it helps the employer provide a really attractive package to the employees, but also stay within a budget because they're not exceeding that $8,000 cap, which they've put in their budget. So how can you go about setting different contribution structures? So this is a big question we get. Sometimes you can change your contributions based on geographic location, job types, staff versus management. Employers can give lower paid employees more coverage. We'll talk about that more provided benefit. The Affordable Care Act, if you're an employer that has over 50 full-time employees and you're an applicable large employer, you definitely want to have your contribution strategy at least set up where the lower paid employees benefit more than the higher paid employees, but there's other compliance reasons to do so. Also, employers may want to give, in certain situations, managers or executive staff more employer-provided money. Employers have member-level rates, but wish to provide all employees with a flat contribution. That we talked about already. But I would say the overall theme of this is you want to be consistent. You know, we have a client that that is in multi-states. They're in about 30 states right now. So they have markets where health insurance rates are much different than other markets. For instance, their Midwest markets are, and we have several clients like this, their Midwest market plans are more affordable than their coastal organizations like New York and California. So they have the need to design contribution strategies that vary in different states. That's compliant. You can also do this by division. So they also have branch offices in multi-states, and some employers want to set it up where one branch would get one contribution and other branches can get other contributions. You can tier your contribution based on job classification. So if management gets 1% or flat dollar amount and all other employees get another, that's compliant. The whole key here is to make sure that not only are you providing and complying with laws that require you to contribute, like the Affordable Care Act, if you're over 50 full-time equivalents, but you're also complying with other laws like HIPAA and Section 105 and Section 125, which we'll talk about in a few minutes. So the key here is to be consistent. You want to be as attractive as you can to your employees. You want to make sure you're doing it in a compliant fashion. If all else fails, you want to make sure that you're offering a level of benefit that's consistent among like employees. So different types of contributions that are utilized: seed contributions, where employers contribute a fixed amount towards a specific benefit. So they pay for the low option only and give one set amount for that benefit. Some employers use matching contributions, and matching contributions really aren't ever used or often utilized in health and welfare plans like medical and dental and vision, things like that. That's more suited towards retirement contributions. And then contingent contributions, where the employee, if the employee contributes X and the employer contributes Y. That we've seen a little bit of, but as over the years, those have diminished as well and are more customized towards retirement plans. I would say seed contributions are what we see the most of, and definitely I would tell you that there has been a shift with employer contributions to more flat dollar plans, which is more easy to budget and identify costs year over year. So UBA is a health plan survey. They survey about 20,000 plans every year. So as of, and again, this is nationally we're looking at. So some of these numbers might actually look pretty low. Somebody might say, hey, I want that plan. But this is a national average of employers. And in 2017 and 18, you can see the employer contributions haven't really creeped up too much from 2017 to 19, whereas the employee contributions have creeped up. So, you know, that's an indication of what is out there. Obviously, you can see employees are experiencing somewhere about 11% year over year. So more cost share is being passed on to employees now than ever before. It is due to rising costs of health insurance, but also due to the fact that employers are becoming more savvy towards having employees make consumer-directed choices. What do I mean by that? Well, if you're an employer and you offer one plan to your employees and you pay a percentage of that plan, and every year you keep renewing that plan, and year over year, the increase is going, you're just splitting the difference with the employees. What you're basically doing is setting up a scenario where every year you're guaranteed to get an increase pretty much from an employer side and the employee side. But most often when employees are paying employers are paying the lion's share of that, it's really the employer that's taking on more of the the increase. So what we've done a lot with our clients, and what is more of a trend, is not just offering one plan, offering a multitude of options. And if you're just working with one carrier, it's sometimes 3 or even 4 options, depending on how large your organization is. Those would be enough to create the kind of menu that would give employees a reason to choose. So employees then start to make choices based on their own needs and not on the needs, and not just choose the best available option because it didn't increase as much for them. So because of that, the trend has been to more of a flat dollar type of contribution from an employer, and therefore employees now are absorbing most of the increase year over year. But what happens is employees will now make consumer directed choices. So if they're on a platinum type plan because it was only costing them very little out of their paycheck, but the employer capped that at a flat dollar amount, and they really don't need platinum coverage. They only go once a year for their preventive care visit, they're healthy. Those employees will start to trend down to other plans that can stay within their budgets, and thus passes on less increase to employees and employers. So I think the trend is definitely going in that direction, and that, we believe, will help decrease costs in the future, or at least stabilize costs in the future year over year. So there's a few different laws that we need to consider when we're designing a contribution strategy, and one is HIPAA. We have to make sure our plan is non-discriminatory, and that really applies to making sure that we're not offering one employee a type of plan that a same like employee would get different contribution. In other words, if you have administrative staff and one administrator is getting 80% contribution and the other one is getting 65% because the other one does a better job, that's not going to be compliant. You're going to run into some HIPAA violations there. You also have to comply with Section 125. And I will start by saying these are not often policed, for lack of a better word, regulations, meaning that a lot of small businesses, if you looked at the smaller type organizations and you looked at whether their plan was compliant or not with some of these regulations, a lot of the times they're not. If you are brought into an audit, in an IRS audit, these are things that can pop up, so you should be aware of them. And anybody that has a Section 125 plan, which means that you are pre-taxing benefits from employee salaries. Now, I will also mention at that point that we run into that a lot as well, where you work with a payroll company, you pre-tax, you report to the payroll company that you want to pre-tax your employees' benefits, but you never set up the Section 125. So that can be a compliance violation in its own that could create a disallowance by the IRS for all those pre-tax deductions. So you want to make sure that you do have a Section 125. They're very simple to administer. They're very cost effective to administer. So there's really no reason in our estimation that you shouldn't have a Section 125, but just so make sure you're having it. But once you do have that, you also have some compliance regs that you need to comply with to make sure that you're utilizing that in a compliant fashion. And then Section 105 really applies more to self-funded plans. The last law that would be the ADEA, which is the age discrimination rules, and you have to make sure that your plans are not discriminating against older employees. The example used is age 40, which I find that highly offensive that that's what they call old these days, but it is what it is. So moving forward, talking about HIPAA, it's something to consider when employers are structuring their benefit plans. Plans may differ for employees. It's okay to have different contributions for employees, but as we talked about before, it's got to be employment-based and it should be consistent with the usual practice of the business. So if employers in one state get one contribution and employers in another state get another contribution, that would be compliant. If employees in the administrative staff get one and sales get another, that would be compliant. But we have to make sure that it's either based on something tied to the employment, either salaried versus hourly, full-time. Most of the time, part-timers are not included in benefits, and you can exclude them from your contributions. Their type of job, their geographic location, their date of hire, how long they've been working for the organization, division, business unit, profit center, whatever the distinctions are within the employer. As long as it's consistent within that distinction, you should be compliant. And I would add to that, these classifications should be added to employee handbooks and all summary plan descriptions. So for HIPAA, there is severe penalties. And if somebody's brought into a discrimination suit, they could find and contacted the DOL, they could find HIPAA non-discrimination rules based on what we just discussed. And that could be $100 per day per affected plan participant. So that can get costly if there's several employees and it's a broad compliance violation where it's affecting everyone. So talking about Section 125, and again, that and 105, which is the self-funded plans. Section 125, really, the general rule is your plans can't be in favor of highly compensated employees. Most employers these days, and the larger the employer, the more evident this is, are designing their strategies where they actually favor the lower cost employees more than the higher cost employees. And I think this is a trend that will continue. It was brought more to the forefront because of the Affordable Care Act. The Affordable Care Act, if you're an employer that has 50 or more full-time equivalents, you're an applicable large employer. And what that means is now you have to provide health insurance coverage that's affordable, meaning it can't cost them more than just about, it varies every year, but it's somewhere in the average of 9.5% to 10% of their income. It can't cost them more. And as higher priced employees go up, that diminishes the amount that employer would have to contribute to make that plan affordable for them. So what has happened is more plans that, especially for 50 plus employers, are being designed where the bulk of the contributions are being contributed towards the lower waged employees, and that scales down as we get to the higher cost employees. And that certainly would be very favorable to the IRS and under Section 125 and be deemed compliant. So there is testing that can be done. And if you work through a third-party administrator that's administering your Section 125 plan or your cafeteria plan, if you have a flex spending account and things of that nature, they can run discrimination tests to make sure that you're staying within those employer contributions in the allowable limits so that plan is not discriminatory. So as we said, what are highly compensated employees under a cafeteria plan? They're officers of the company, they're 5% shareholders, highly compensated employees, spouses or dependents of any preceding individuals. And we have an example. Just the other day, an employer called us about their contribution strategy and they needed to change it. They were brought into an IRS audit. They're an S corporation, and they were found that they were running contributions very innocently. And we'll talk more about that because sometimes these discriminations, they come up. It's not they're not of any malicious intent. They're just out of lack of awareness. And in this case, the situation, they were running payroll deductions through the corporation, pre-tax for owners of the corporation. And that is a compliance violation under Section 125 because it can make the plan discriminatory. So these are real things that are happening out there. They should be looked at. And I think that, a lot of cases, especially in smaller organizations, even though they're not often looked at by the employer or by the IRS, there are a lot of violations that are probably out there already that should be looked at. And I might add that there's simple ways that can alleviate those concerns where you don't really have to disrupt the entire amount of the entire strategy of your plan, you might just have to tweak it a little bit and to make it fall into compliance fashion. So for what is a highly compensated employee? So for 2020, the applicable compensation is $125,000. So anybody that is above that would be considered a highly compensated employee and should be considered in the contribution strategy. Key employees are those that make over 185 and 1% owners in excess of 150,000. Those are all highly compensated employees as well. And there's a few different tests that can be run to view this: the eligibility test, the contributions and benefits test, and the concentration test. Basically, those three tests will take a look at the contributions of the plan and whether they're being heavily weighted towards highly comped employees. And then also you want to look at whether the benefits in the plan are only, the best benefits are only affordable or available to those highly comped employees. So there's a few different aspects of these regs that should be considered. So as we said, the contribution and benefits test, it can't be in favor, can't discriminate in favor of highly compensated participants. The cafeteria plan must satisfy this component with respect to both benefit availability and utilization. This is what we just talked about, and it's got to be uniform for all elected qualified beneficiaries. So again, talking about the disproportionately utilize highly compensated employees, you want to make sure that if the contributions are heavily weighted to those higher compensated employees, that's going to fall outside the compliance guidelines. So you want to make sure that those are more heavily aggregated to the non-highly compensated employees, and there's calculations that can be it can be done through third-party administrators or run tests to make sure that that's the case. So as we talked about before, unless this is often looked at or tested, it can be really difficult to spot a discriminatory plan. An owner of a company who is on the plan could be on the plan, running payroll for themselves, innocently deducting contributions for themselves through the plan, just like they do for everybody else. And even if those contributions are similar in percentage, if that owner takes a higher plan because they're more highly compensated than others, that could be a compliance violation. So there is a lot of that out there that is unknown. So like I said before, it's very innocent. A lot of these violations are out there. They're not really often easy to spot. And so the consequences of failing that is those highly compensated employees could now be responsible, just like in a 401k plan that's top heavy or fails the actual deferral test. Those highly comped employees may be responsible for being taxed on those contributions that they made that were made towards them. So there are some hefty penalties if this is not complied with. So for those who are self-funded, and in New York, self-funding, you are only able to self-fund if you have more than 100 full-time equivalents. So that is different in varying markets. There are markets outside New York where you can self-fund down to 5 employees. But in New York, you have to have over 100 employees to be self-funded. If you're self-funded, you do have to comply with Section 105H, which is very similar to the discrimination regs that are for Section 125. So again, if for the purposes of 105H, if you're one of the 5 highest paid officers, you're a shareholder who owns more than 10% of the value of the employer's stock, and you're among the highest paid 25% of all the employees, and you are receiving more of the contribution than the non-highly compensated employees, that could be a compliance violation And again, could be in a situation where the excess reimbursements that were provided to the highly compensated employee would wind up being taxable at another point. So again, the larger the amount of employees you have, the more complex your plans are, the more you definitely want to look into this. And again, we're getting pretty deep in the weeds here. Most contribution strategies, when they're set up, are set up in a fashion that it's easier to be compliant. Like we said, a flat dollar amount that is consistent throughout classes, and takes into consideration varying salary amounts, or just setting up an age-based type of plan that contributes more to the lower waged employees and less to the higher. Those are simple strategies that are able to be set up where you can ensure that your plan is going to pass those discrimination tests. The last one is the ADEA, and it's just for this regulation, you just want to make sure that if you're in a market that has age banded rates, where your employees are receiving rates based on their ages, that those bands don't fall within more than five years. So they're banded on a 5-year basis, and then it provides all employees with an equal percentage contribution. So the ADA is not violated when benefits provided to older workers are equal to benefits provided to younger workers. So you want to make sure that the overall contributions to the plan don't favor the younger workers more than they do the older workers. So if an employer charges older employees more for the same benefit, they really should be able to show that, one, the benefits become more expensive with increasing age. So the plan is age banded. The benefit is part of a bona fide plan. It's a compliant plan. It should be part of certainly the Affordable Care Act definition of metal tiers from bronze to platinum would be a compliant plan and a bona fide plan. You want to make sure that the actual amount of the cost incurred on behalf of the older worker is no less than what is made for the younger worker. So employers that are paying a lot more for their coverage than younger employees could present compliance problems, and that is a challenge when trying to be compliant within an age-banded plan. So also, you want to make sure that the benefits are more expensive only to the extent that they need to achieve approximate equivalency. So you want to make sure that those benefits they're more expensive, but that's only to keep the plan within those compliance guidelines. And you don't want to use age brackets larger than 5 years. So they should be age banded within 5 years of each other. Anything more than that is going to cause compliance issues. This is a question we get quite often, and the question is, can I change my employer contribution level mid-year? So in the instance of the example I gave before, where we were called by one of our clients and they were under an audit, and they were in a position where their plan could be deemed that it was benefiting highly comp employees. So they have to make a change to their employer contribution. So we get that a lot. I will say we got it quite often due to the recent furloughs and layoffs due to COVID-19. And so there were employers that could not afford to keep their level of contribution at the same level it was before. There were various reasons why they would want to change. I would say the answer to the question is yes, but there are some steps that need to be taken in order to do so. And you definitely do not want to just spring that on an employee, especially if you are lowering contributions. I mean, obviously, if you're raising contributions in mid-year, I don't think any of your employees will balk at that. However, in most cases, it's the other way. We have to make a change, and we have to either keep up with an increasing medical insurance plan and change the way we provide our contribution, or we have to just lower it altogether due to budgetary constraints. So you can do it. You definitely want to give your employees enough time to digest this. They should be notified in advance of the plan change. You don't want to spring it on them, from a compliance standpoint, but also from a recruiting and retention standpoint. Employees are not going to be happy if they find out suddenly that they're going to be, their payroll deductions are going to go up. So you definitely want to let them know that. And depending on the types of changes to the plan, there's definitely a few different timelines that employers have to abide by, and they need to either give 60 days prior notice to the change. They need to give no later than 60 days after the change or within 60 days of the change. So it's got to be done at no later than 60 days after the change is occurring. And you want to notify them within 210 days after the end of the plan year. And you'll find that these fall under the ERISA guidelines of us that are consistent with summary plan descriptions and the material modification rules for any time you change a plan or you change a benefit within the plan. So if you do change your contribution, that could trigger a material reduction in covered service and therefore give your employees rights to certain changes in their benefits. So depending on what the changes are made to the plan, like we said, employers must provide notice in one of 3 timeframes. But as best practice, as we said, an employer should give advance notice, and for practical purposes, employees should be told first. But there's something else called a significant cost change, and that could trigger a qualifying event. So in its simplest form, if you're an employer and you offer multiple options in your plans, your employees may now have a qualifying life event due to your change in benefits, and that might allow them to be available to change their plan in mid-year to the lower cost plan. This does not apply to a flex spending account, but other benefits under cafeteria regulations, this could be the case. So that cost of change being passed on in the form of a participant's contribution, it must be significant. And a determination must be made whether an alternative coverage is similar. And I can say, though, that what is similar is a very broad definition. For instance, similar does not mean that there's an affordable plan that has the exact same benefits as the plan they were choosing. A similar type benefit could be something that falls within the guidelines of a credible plan, and for instance, means that they have an HDHP or a health savings account plan that's available to them versus the HMO they were on. So even though those 2 plans are very different in the way they accrue benefits and pass on costs to employees, they still would fall in the guidelines of similar type benefits, and therefore employees would be able to make those changes within that plan year, in the mid-plan year. Other things that come up, and this came up a lot during the furlough situations during COVID-19, pay shortages. So sometimes when employees are on, when they have to take a low rate of pay, they take an unpaid leave of absence, or they're based on commissions and they're earning lower commissions or tips. There's wage garnishments. There could be situations where the employee doesn't have enough income to deduct these, and what does an employer do and what they're allowed to do. So again, they should follow consistent rules when it comes to this, and it must be a shortage combined with an event that causes a loss of a benefit eligibility. So like we talked about before, if they're raising contributions, these kind of things could come up and cause qualifying events. So it leaves the employer to determine how are they going to recoup these funds when the employee is out, and they should follow guidelines similar to Family and Medical Leave Act. So they could ask the employee to prepay their benefits. That is compliant. They could ask them to pay as they go on an after-tax basis. So if the employee is not earning income, they could require them to pay them in the form of monthly premium checks, similar to COBRA. and that and they can do that on an after-tax basis. They can also do salary catch-ups, and employers can be liberal with how they do this. Most of the time, employers will determine what is feasible for them, but they can do salary reductions. So in a case of a furlough, let's say where the employer is confident that they'll be bringing that employee back in 3 or 4 months, they can decide that once they return to work, they can do a salary reduction to catch up to past premiums, and they can be flexible with the time frame in that they can do that in order to allow the employee to have an affordable amount deducted from their paycheck. So employers should have written policies that address all this. It should be in employee handbooks. It also should be in summary plan descriptions. There's many employers that are unaware that ERISA does apply to most employers. And so ERISA expressly states that all employers that offer benefit plans should have summary plan descriptions that go along with that. They should be given to their employees within 90 days of the plan, of the summary plan description being set up. And then goes back to those 60-day rules where if there's any changes to those plans, employees should be notified of those changes in a written fashion. So long story short, handbook should be updated, summary plan descriptions should be updated anytime there is some type of change to material change to benefits or to payroll contributions. So employees, again, they should be allowed uniform periods of time to pay for back or missed contributions. I think we covered that already. And all of this, it should be in writing. It would be in many employers' best interest to require that health coverage be funded first for the purposes of healthcare reform. And that is, ties back to what we talked about as far as the Affordable Care Act goes. So that was a broad overview. We've hit our time limit. I will now ask if anybody has any questions. I'm happy to address them now. Also, if anybody has any questions after the fact, you can feel free to reach out to us. If you just want some strategy or some guidance about your contribution strategy and either the one you're utilizing now or anticipating, we're happy to advise on any questions related to that. So with that, I will open it up to any questions. Okay, so it doesn't seem like we have any questions. As I already mentioned, we're going to be sending the copy of this presentation out after the fact. We'll email it out to all the participants, and we will also send a link to the recording of this so that you can pass it along or view it at a later date. And with that, I want to thank everybody for joining us today, and we look forward to seeing you on the next version of the Vanguard Employer Education Series, which will be 2 weeks from today. Thanks, everyone. Have a great day.